Let's start here. President Cyril Ramaphosa met the Vice President of the United States, Kamala Harris, at her residence in Washington, D.C. Ramaphosa expressed his gratitude for the U.S. for the country's continued support of South Africa. A busy day ahead for the president that started with a breakfast meeting, and he has a number of engagements before he heads to the White House to meet with President Joe Biden. Now, from the South African side, concern about U.S. intentions to extend sanctions against Russia. Now, a number of issues are expected to be discussed, including trade and climate change. Another story making headlines today, the public protector Advocate Busisiwe Mkhwebane has opposed the application of the acting public protector Mkhwebane to intervene in her application to go back to work. Representing Mkhwebane, Adv Dali Mpofu said the acting public protector was conflicted in that she would cease to act in the position if Mkhwebane returns. Mkhwebane applied to intervene in the case to submit the true facts about the office of the public protector after Mkhwebane alleged inaccuracies. Mkhwebane's legal representatives, Timothy Brainders, says the acting public protector has a direct and substantial interest in the matter and should be allowed to intervene. Now, the Western Cape High Court will rule on this particular case. Let's stay with this particular story and speak to Mpumelelo Zikalala, who is a legal analyst. Thank you so much, Kuzen, for your time. Advocate Dali Mpofu says this is a very clumsy attempt to resuspend the public protector. He also argues that the High Court stated that its invalidation of Mkhwebane's suspension was immediately effective. I'm sure you've listened to the arguments. What is your reaction to what we've seen so far?
My reaction is that in compliance with the Constitution, you have to remember what Section 172 actually states. And it is very specific in the second part of it, where it relates to the powers of the Supreme Court of Appeals, the High Courts, and equivalent courts, in terms of, in instances where they've declared the conduct of the president has been unconstitutional, it needs to be confirmed by the Constitutional Court. I would seem to align myself with that particular argument. Now, in this case, it is all centered around the conduct of the president. Remove the conduct of the president, the suspension of the act of the president, you don't have a case at all, or there's nothing to discuss, or there's no dispute. So if the central part or integral part of this particular dispute is going to be the conduct of the president, then it means that it must be confirmed by the Constitution at the end of the day. So I would say confirmation of this particular order, the order that was issued by the Western Cape High Court, is crucial, and seem to align myself with that particular type of thinking. So this type of application cannot be said to be an attempt to resuspend the public protector. And I think this is what the Western Cape High Court is going to come to, or may seem to align itself to.
I suppose then you understand, then listening to you, why Judge Nuku asked why Advocate Mkhwebane, for example, could not wait for the appeal to be heard before going back to work. But Advocate Dali Mpofu saying that Mkhwebane is the victim of the most egregious abuse of power in this republic, and questions, and also questioned why she must be asked to wait. But listening to you, you seem to be leaning towards the fact that the court may say wait.
The court may say wait, because let's also remember, if you go to court on an urgent basis, you're basically saying, before I deal with the merits of why I'm here, I need to deal with the principles of urgency. Instances of protecting an interest or right must be proved, which I think in this case, she can easily do that. Then the second one is the irreparable harm which you are going to suffer. The mere fact that you have an order of court which says you must go back to work simply means that if you follow the collect legal prescripts, the court may be able to repair that particular harm. So we're not going to suffer any irreparable harm by not going to work today. Then secondly, let's look at the work of the public protector. It is not central to the current public protector, which is Advocate Mkhwebane. It is the office itself. So no matter whoever that individual is there, as long as the appointment is done in accordance with the Public Protectors Act, where the person who has the correct qualification, who is fit and proper and is able to take decisions, it's easy for us as members of the public to hold that particular individual accountable. So even if you remove Advocate Mkhwebane from the Public Protector's office, the office will still be able to function, and us as members of the public will still be able to monitor whether the office is operating within its optimal best, or is it applying any type of bias in terms of the investigations in which it is conducting. So on the irreparable harm which is going to be suffered, I don't think she's going to survive, or maybe the odds are going to be in her favor, as she has come to court on an urgent basis. And that is the court must come to at the end of the day and say, we must look at all these elements before we ascend to the next stage of saying, let's now discuss the merits of this particular matter. Why are you saying that the Constitutional Court cannot confirm our order before it is declared as final? All that you need to do, or that we need to do as courts, is to follow the Constitution as it is written. And it is clear, any conduct of the President must be confirmed, and declaration of the conduct of the President as being constitutionally invalid must be declared by the Court.
So I suppose then, we can then be asking questions around the acting public protector's intervention application, saying, Mkhwebane's lawyers, for example, saying this is an abuse of process, but her lawyers are saying they would like to address some untruths and inaccuracies in this particular matter. How unusual is it that we see a scenario like this one play out in court?
It is a bit unusual, because you see, if you go to court, you must show how interested you are. What's your interest in this particular matter? Tell us the right in which you seek to protect. If you say you want to protect the integrity of the public protector's office, maybe I would understand and give it to them and say, okay, you can go to court and argue that. However, it must be solely based on that particular conduct and nothing more. The point could have been better argued by an amicus, for example, who would say, we want to protect the integrity of the office of the public protector, which is why I want to highlight these things and say, us as members who are not interested in the outcomes of this particular matter, our interest is only to make sure that we're able to protect the integrity of the office. We feel it is important that we need to highlight these particular points to the court, so that when you are making a decision at the end of the day, it's easy for you to come to a conclusion which is going to be just and fair. Where we are coming from in protecting this particular office, we are saying, even if that particular decision to suspend the public protector was incorrect, let's look at where we are in this stage of the committee, of the parliamentary committee. Is it fair, or is it just inequitable to have a person who you're going to report to during the day or the day before, when the next day you're actually testifying against them? Where is the element of non-biasness? Where is the element of not being influenced, whether directly or indirectly, by that particular individual? How then do you seek to ensure or protect the individuals who are going to testify against the public protector at a later stage, if they are going to report to her every now and again? So there was rationality in including that particular provision in the Constitution, in terms of saying, when these particular proceedings have started, you would find that some or most of your witnesses are going to come from the office itself. So to protect the integrity of those proceedings and to make sure that people are able to give evidence without any fear or favor, let's remove the public protector and allow somebody else to act in line with the Public Protectors Act, so that when we deal with the evidence which is going to come in, it is easy. Again, let's remember, what are we investigating within the public protector or the mishaps? It is instances of misconduct, incompetence, and the last point seems to have I've forgotten the other one. But at the end of the day, how are we going to deal with the misconduct of the current public protector if I don't tell on her for a loosely translated? Because at the end of the day, I must be able to say, on this day, she came in and said, this is what you must do, and this is where we are. And to me, that's constituted as misconduct. I can't do that if tomorrow morning I need to go and report back to her.
All right, it's interesting how this one is going to play out. Let's see then how the court, I suspect they may even reserve judgment, given the fact that they've had a full day of some of these arguments. But let's leave it there with you for now, and we'll see how this matter unfolds. That's Mpumelelo Zikalala, the legal analyst, as we look at this particular application in the Western Cape High Court by Advocate Mkhwebane, asking that court to enforce her return to office.